Hello everyone, I'm Stephanie and I'm a paralegal here at Landlord Chambers. In this video I'm going to be giving you a very brief explanation of commercial property possession and lease forfeiture. If you like this video then please click like down below and don't forget to subscribe to our channel. Landlords of commercial properties have the right to repossess their properties under common law if the tenant has breached the terms of their lease, and this is most commonly seen where there has been a non-payment of rent. The landlord has two options: either to forfeit the lease by peaceable re-entry, or the landlord can apply to the court for a writ for possession. The right to forfeit a commercial lease is a type of remedy for a landlord. The right to forfeit is a solution for landlords to bring an end to a lease following a tenant's default of the lease for non-payment of rent. Forfeiture of lease on this ground is only available if there is an express forfeiture clause in the lease and the conditions are met. For example, the landlord can only forfeit the lease for non-payment of rent if the lease itself contains a clause that states that forfeiture will be triggered when the tenant fails to pay their rent. This right cannot be implied. This right can also be exercised in the form of peaceable re-entry. First, the landlord must communicate his unequivocal intention to bring the lease to an end, followed by the act of re-entering and securing the premises by changing the locks. This act is commonly enforced by a certified bailiff on the landlord's behalf, and the tenant will know that the lease has been brought to an end from the notices affixed to the premises. Before exercising the right to forfeiture for breach of lease clauses, a notice must be served on the tenant, and this notice must specify the breach, require it to be remedied within reasonable time if it is in fact capable of being remedied, and require the tenant to pay compensation. Once proper notice has been served on the tenant, then the landlord can exercise his right to forfeit the lease. As an alternative option, the landlord can also apply to the court for a writ to repossess their commercial property. Possession orders can be made in the following situations. The tenant does not have the statutory right of security of tenure under the Landlord and Tenant Act 1954, or the tenant has breached a term of the lease. The right of security of tenure allows business tenants to remain in occupation of the specified rented premises even after the end of its lease term. This right is only enjoyed if the lease is a tenancy that is occupied for the purpose of business. If the tenant does not qualify, then the landlord has the right to repossess the premises after the expiry date of the lease. A possession order claim will be processed by the court and a hearing date will be set, whereupon a judge at trial will decide whether or not a possession order is granted. At Landlord Chambers, our landlord and tenant solicitors and barristers regularly assist with many contentious and non-contentious landlord and tenant cases. We have represented and assisted many clients from all over the world, achieving successful outcomes for them. If you liked this video and you want more information, then please check out our website at landlordchambers.com. Our contact details are listed in the description box below if you'd like to give us a call for further information. I hope that this video has been informative, and if it has, then please give us a like down below. And as always, don't forget to subscribe to our channel so you don't miss out on any of our videos. Thank you so much for watching. Bye.